Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much, and good morning. This first case on our list today is Commonwealth versus Adam Walker, number 2021-0417. Before we begin, I just have a few preliminary remarks. First, I'm going to introduce the panel to you. My name is Ariane Buno. I'm joined today with Justice Young Shin and Justice Sabita Singh. As you know, we're on a remote platform today. Upon occasion, we have some technical difficulties. If we do, just be patient with us. We'll be patient with you. They generally are resolved quite quickly, and no one will lose any time as a result of any hiccup that we may have. As I'm sure you know, you both have 15 minutes to present your argument, and there is no rebuttal in the appeals court. So with those preliminaries aside, let's start. We'll hear first from Attorney Salos. Am I correct? I called him. No, I'm sorry. No, I'm sorry. I'm looking at my screen and I'm seeing the two of you at whether you would be in the courtroom, and I made a mistake. I apologize. We're going to start here first from Attorney Del Signore.
Good morning. May it please the court. Tony Del Signore for Mr. Walker. And, you know, at the risk of stating the obvious, this case has a somewhat long and winding history. So just for the purposes of oral argument, if possible, I'd like to try to focus on a couple of the issues related to the prior writings. So specifically with respect to the 2010 writing, I'd like to look at the prior bad acts issue. And then with respect to the 1999 letter, I would like to look at the privilege issue, and then possibly, if time, any of the ineffective assistance claims that sort of flow from that. I understand and I appreciate the fact that the panel has read everything that was submitted. So I just did want to say, to the extent that I don't get to anything in the oral argument, I'd obviously urge the panel to consider everything, including the claims that were raised in Mr. Walker's pro se motion, which I'm sure you will. But obviously I'm happy to answer questions on anything that the panel has. So with all that said, the 2010 handwritten note, Patty, I don't make the exact same mistake twice. I'm laying it all on the line, signed Adam Walker. The prejudicial effect of that note outweighed the probative value. And to that extent, it shouldn't have been allowed. With respect to the probative value is minimal. Prior to trial, the Commonwealth argued that very brief sort of scrawled snippet would be relevant to Mr. Walker's syntax or style. I struggle to see how two scrawled lines is particularly probative of someone's syntax or style, particularly when the jury is then being asked to compare that to a card or a letter that is, obviously much longer, more considered. So the probative value in terms of the syntax or style is at best minimal. I understand that the Commonwealth has argued and is arguing that the handwriting is obviously relevant. And I'm not suggesting that handwriting isn't relevant. I'm not suggesting that the jury wouldn't have been competent to assess the handwriting. I'm simply suggesting there are several factors in this case that really undermine the probative value of the handwriting with respect to this particular.
Just one question. Would you agree that the issue of the handwriting was probative in terms of establishing the identity of the person who sent the package to Ms. Chunky?
Yeah, absolutely. No, I would. But with respect to this particular note, the 2010 note, I think the handwriting is less probative for a number of reasons. So, I mean, one reason is there's already at this point when this exhibit was being admitted, there was already another much longer writing sample that had been admitted at trial, and I understand that I'm contesting whether that was it properly admitted, but nevertheless, at the time of trial, it was there for the jury to consider. And to that extent, where there's a big long letter, I fail to see how two sort of scrawled handwritten lines are going to really push it over the top in terms of providing that kind of handwriting comparison. So I'm not saying that the handwriting is irrelevant, but there was handwriting there. And then with respect to this particular note, You know, the complaining witness testified that she didn't recognize Mr. Walker's handwriting. And again, not saying that the jury can't make its own determination, but I think it really undercuts the Commonwealth's argument that Mr. Walker's writing was so distinctive that, you know, it's absolutely going to, you know, prove identity. Again, not saying it's irrelevant, just saying that it really undercuts the argument. And I would say, you know, the Commonwealth cited in its brief O'Connell. I don't think that this is like O'Connell. In O'Connell, you had 4 checks, you know, 2 signatures on each check, and the jury's being asked to compare like to like to like, signature to signature to signature. And that's not the case here. I mean, again, this is a scrawled, you know, just based on the appearance, a scrawled note that the jury's being asked to compare to a much longer, more considered, presumably, writing sample. So,
Counsel, would I be correct to say that this letter was admitted solely as a handwriting exemplar and not for any other purpose?
Respectfully, I disagree. I don't. Well, I think it's a little bit of a question. So, you know, the ruling was that it was admitted for identity, but at trial there was also some. You know, the judge did make a statement with respect to the nature of the relationship. So I think that there is some question whether it was admitted for the purpose of the nature of the relationship. And if that's the case, I would argue that that would be irrelevant in this particular. I mean, I'm not saying that it's never relevant.
The judge said that in the final charge?
Pre-trial, when they were discussing,
Okay.
I can get a page site for you, but pre-trial, not in the motion to eliminate hearing, pre-trial, Judge Ginsburg mentioned that it would be relevant for the nature of the relationship. And I can get a site for you. So I believe that would have been at well, it was somewhere early on in the first in the trial volume. I believe it was somewhere in the teens. I apologize, I don't have the exact.
That's all right.
site.
That's all right. I'm sure we can find it. I think where I'm struggling with this argument is that it doesn't seem like the letter was offered as a prior bad act, in the sense that it wasn't being offered to support any inference that because he sent that letter in 2010, he must have been the person who sent the Christmas package. It wasn't offered, for instance, as modus operandi or similar acts or anything like that. It really does seem like it was offered for the jury to compare the handwriting. So in that sense, it's hard for me to even see it as a prior bad act. The Commonwealth could have introduced any sort of letter from the defendant, in other words, even if it wasn't written to the victim, as long as it was his handwriting.
Right. Oh, I agree with that completely, but they could have done it. They could have had any sample of handwriting. So if it was, you know, respectfully, I would say if it was truly only for the purpose of handwriting, then they, exactly as you said, they could introduce any handwriting sample at all, whether it was written to the complaining witness or not. And, you know, respectfully, I actually would suggest that the prosecutor did reference the evidence in a way that it veered into prior bad acts, where as soon as he offered it into evidence and published it to the jury, he referenced, now we've gone over prior, you know, communications and the no harassment orders that resulted. And I think that kind of a statement absolutely does tie it to, you know, a prior bad act. It ties it to, he sent these messages in the past and they were either harassing, or they resulted in no harassment order, or they violated a no harassment order. So when the prosecutor frames the evidence that way, I would suggest that that it is being offered for prior bad acts evidence. And I would also note that the prosecutor referenced it that way in the closing argument, that, you know, he sent her stuff in the mail before he sent it to her this time. So I actually would suggest that it is being offered for a prior bad act purpose.
Okay, I understand.
So I can see that I'm kind of used more than half my time. So I'm going to actually switch, if it's okay with the panel, to the privilege issue. And I'm really making two arguments with respect to the privilege issue. And again, I just want to be clear because I'm not sure if it was totally clear. I'm only arguing the privilege with respect to the 1999 letter. I'm not arguing that the 2010 note was privileged. But I'm arguing, first of all, that at the motion in limine stage, there was sufficient evidence for the judge to have found that that was a privileged communication. And to the extent that she found that it wasn't, that was error. I'm also arguing that the Wayside file provided substantial other evidence that really, more clearly established that the privilege should apply. And to the extent the trial counsel didn't investigate that Wayside file and didn't get that the data in the file that would have substantiated the privilege claim, to that extent, he was ineffective. So, I think the first question here is, was the complaining witness, a qualified person under privilege? And obviously, I'm conceding that the complaining witness wasn't a licensed social worker at the time the communication was made. I'm not suggesting that she was. But I think it's important to look at how broad some of the language in the statute is. I'm looking at 112 section 135A. No such social worker, colleague, agent, or employee of any social worker, whether professional, clerical, academic, therapeutic, shall disclose any information acquired or revealed in the course of or in connection with the performance of the social worker's professional services. So even on the basis of what was presented at the motion in limine, I think there was a sufficient inference that the complaining witness was a colleague or an agent of a licensed social worker. And that's because there was plenty of evidence that she was working for a social services agency that's providing, undoubtedly clinical social work services to a child who's committed to, at that time, the Department of Social Services. And to that extent, it's almost impossible to imagine that someone in the complaining witness's position wouldn't be working hand in glove with a licensed social worker. If the panel disagrees with that, I would suggest that the Wayside file really makes that point much more clearly, because and I think the key document here is that the January 5th, 1999 treatment plan, which is at the first appendix, page 80, where the complaining witness is listed as quote unquote clinician responsible for 3 different treatment functions. And again, I'm not saying she was a licensed social worker, but she is listed as a clinician. I understand that Mr. Walker had a sort of a named quote unquote primary clinician, but he's not the person that's providing those services. He's not the person. If you look at the treatment plan, the people providing the services are the complaining witness and David Morris. And it appears for the most part that David Morris assigned his name as an intern. And obviously the complaining witness was in social work school at the time. But if she is providing clinical services on a treatment plan, I can't see how she wouldn't qualify as either, at the very least, a colleague of a licensed social worker, or, more appropriately, where she's the person providing the services, she is working as an agent of a licensed social worker.
Counsel, assuming we were to agree with you, what's the prejudice from admitting this letter? There's nothing in the content of the letter that seems to put the defendant in any sort of bad light. It's just a goodbye letter as far as I read it.
Yeah, I understand your question. And I think that the issue is, number one, where we're dealing with, the issue in the case is about mailings, right? And about letters that Mr. Walker either is alleged to have sent to the complaining witness. And this is going back, at this stage, we're going back almost 15 years. The trial was in 2014. This letter was 1999. The jury's looking at a letter that's 15 years old. And it really creates this image of, oh my God, this guy has been sending her stuff like this for 15 years. And I agree with you. There's nothing in the content of the letter that puts Mr. Walker in a bad light. But it does create this sort of picture in the jury's mind of this person has been sending the stuff over the course of 15 years, at least.
Wasn't this letter handed to her directly? It wasn't mailed, right?
No, that was the testimony. I'm not, and I wasn't necessarily saying that mailed. I was just more saying that he's
Okay.
been giving her, corresponding with her, giving her letters, email, whatever the case is. So, I think that's the prejudice. I think that's the primary prejudice with respect to, the case and why it made a difference. And I do think that it made a difference for that reason. But I think it's, I think it's also just important to note the fairness of this and to look at the purpose of the statute in terms of like upholding someone's the privilege in the circumstance to encourage that kind of communication. If you look at like Call It talks about the purpose of the statute, and to look at the circumstances of this, accepting the way the evidence was presented, this is a letter written by a minor, pursuant to a treatment plan at a social services organization where they were a resident when they were a minor. And the idea that that would be offered at a criminal trial 15 years later, to me, really is a betrayal of the purpose of the statute. And I don't want to sound pie in the sky, but to me, it seems wildly unfair. And I have 10 seconds left, so happy to answer whatever questions the panel has.
I don't see any questions, and I want to reassure you not to worry about the fact that you haven't touched upon everything that you brought to our attention, including your client's pro se motion. But we will, you're absolutely right, consider all of it, and none of it's waived, of course. All right.
Thank you, Justice Vino. I really appreciate that.
No problem. Thank you. All right. So now it's the time to hear from the attorney for the Commonwealth.
Thank you, Your Honor. Good morning. May it please the court, Abigail Solois on behalf of the Commonwealth. This appeal stems from the defendant's 2014 conviction of harassing the victim, who the defendant met in a group home in 1998 and 1999, therein violating a harassment prevention order. The Commonwealth respectfully asks this court to affirm the defendant's conviction and affirm the trial court's denials of both of the defendant's motions for new trial. So if I may, I'd like to begin with or focus on the admissibility of the letters at issue and the privilege. And of course, I'm happy to answer any other questions that the panel has. To begin, the court properly admitted the 2010 letter, which, as my brother mentioned, was 2 lines, 2 handwritten lines in his signature. And the admissibility of that hinged on its status as evidence of identity. And the jury, of course, was entitled to, even if the victim she testified that she didn't recognize the handwriting, that wouldn't preclude the jury from comparing the handwriting. And even though the facts of this case, of course, are not the same as the O'Connell case, it's clear from the Mass Guide to Evidence that, expert opinion is not required, and they could certainly make that comparison in their deliberations. Also, the motion judge and the trial judge carefully limited any risk of prejudice to the defendant when it came to this piece of evidence. So Judge McCarthy, the motion judge, she precluded, there was pretty voluminous email communication between the defendant and the victim in this case, and she didn't let any of that in as overly prejudicial and not probative. And then at trial, Judge Ginsburg provided the jury with a limited instruction that the mention of other acts allegedly done by the defendant could be considered solely for the purpose and the limited issue of the relationship between the defendant and the victim and the identity of the alleged perpetrator here. So they really did their best to narrow this and to limit any possibility of prejudice. And if I may, I want to move on to the second piece, which is the 1999 letter. In this case, there was no social worker-client relationship between the defendant and the victim. And as we know from the Pear case, it says the mere assertion of a privilege does not establish that any such privilege, in fact, existed. And it's clear from the record that this individual, she did not have a social worker license at that time. And she testified that when she was working at Wayside, the group home, she was working under bachelor level staff and not under the supervision of a licensed social worker. And the jury, of course, was entitled to credit that testimony. And as my brother mentioned, there was somebody else, a psychologist by the name of Michael Prescott, that was the defendant's clinician at Wayside and not the victim.
We can't look at her trial testimony, right? Because the judge made the ruling before trial. We have to look at what the judge had before her. Would you agree with that?
Yes, but I believe that the defendant moved again to strike that at trial. So I believe the motion was 2 times, if I'm correct. And if I'm wrong on that, I can double check it and certainly send a letter to the court, but I'm fairly certain there were 2 motions for that. But even if, for the sake of argument, and the Commonwealth is certainly not conceding this, but even if there was a social worker-client relationship between the 2 individuals, the letter and communication did not relate to the diagnosis of treatment. So even if there was a privilege, it wouldn't cover a letter where the defendant is merely saying goodbye to somebody that worked in his program before he left. He also was not a minor at the time. He was 18 years old. So of course, under the statutes and regulations that cover the Department of Children and Families, children can sign in for services through the age of 22. So he was not a minor at the time that this document was written. But going back to the communication, so Chapter 112, Section 135B covers communications between a client and a social worker relative to diagnosis or treatment of a client's mental or emotional condition. And that's not what we have here. And the other thing is, even if, going further, even if the relationship existed and this was the communication that the statute intended to protect, the legislature also has said that the privilege does not apply in any criminal or license revocation proceeding in which the disclosure is necessary or relevant to the social worker's claim. So here, this communication is relevant to the victim's claim because it provided evidence, of identity for the handwriting comparison. So I don't want to spend too much time talking about the ineffective assistance claim or the defendant's claim about the second motion for new trial. The Commonwealth will rest on its brief as far as my second 2 arguments, but I just wanted to add also that even if the 2010 letter and the 1999 letter were totally kept out, there was more than sufficient evidence for a jury to find that, and that was on the basis of the victim's testimony, that there was enough information that this package was sent by the defendant. So there were statements, for example, that were in the text of the card that related to language that the victim had used. So obsessive, creepy stalker was one of them, and references to the victim's sister and leaving the victim's sister alone. So they were identifying things in the context of the letter, even though Mr. Walker didn't sign his name, that the victim knew that the package was from her. So she also had checked with other people in her life to confirm that they had not sent her the Christmas package. So the jury could have found, in the light most favorable to the Commonwealth, sorry, I don't know, something stuck in my throat, that the evidence, there was more than sufficient evidence to find the defendant guilty of this offense. So if there are no further questions from the panel, the Commonwealth respectfully asks this court to affirm the defendant's conviction and affirm the court's denials of the defendant's motion for new trial. Thank you.
All right, just 1 second. I'm going to check with the panel to see if there are any follow-up questions from either of my colleagues. And I see that there are none. So we accept your case, the remainder of your argument.
Live and recording.
Thank you very much. Okay, good morning. This case is Commonwealth versus Oscar de los Santos. 2021-0363. I'm going to begin by introducing the panel to you. My name is Ariane Buno. I'm joined today with Justice Young Shin and Justice Sabita Singh. I know you've both argued plenty of times before in the appeals court, but I'll remind you that you each have 15 minutes to present your argument, and there is no rebuttal. We appreciate the fact that you're participating on this remote platform today. Upon occasion, we have a few technical snafus. They're usually resolved quite quickly, and I just want to assure you both that you won't lose any time as a result of any small break that we may or may not have to take. All of that said, as you know, the seal will quickly turn into a timer once we start, which we're going to do right now. And Attorney Spurlock, you may begin.
Thank you, Your Honor. May it please the court, Matt Spurlock in this consolidated appeal for Mr. De Los Santos. Now, the issue on direct appeal here is straightforward. Mr. De Los Santos has consistently asserted that he did not waive his Miranda rights when he was questioned in custody at the scene of the arrest. There was little doubt that the warnings were at issue at the hearing, which is why the prosecutor extensively questions the witness regarding them. And the motion judge directly addressed this issue in an entire section of his memorandum of decision, concluding solely on the basis of warnings allegedly given in Spanish, that Mr. De Los Santos had knowingly, voluntarily, and intelligently waived his Miranda warnings. Now, that finding was not supported by the evidence, and it is clearly directly at issue for this court's review. The only evidence in support of that finding was testimony of two witnesses from the Commonwealth, Officers Noyes and Moody, who by their own testimony did not speak or understand Spanish. We also have testimony from the Commonwealth's own witnesses, credited by the judge, that Mr. De Los Santos did not understand English and required, therefore, that the Miranda warning be given in Spanish. Because the Commonwealth failed to meet its threshold burden to establish that a valid warning was given, a warning that was understandable to Mr. De Los Santos, it failed to establish that the Miranda warnings had been waived. And because the confession, the incriminating confession to essential contested elements of the charge, which was a charge of constructive possession, was central to the Commonwealth's case, the admission was certainly not harmless beyond a reasonable doubt.
Did the defendant's motion properly give the Commonwealth sufficient notice as to what the true issue was here?
Yes, Your Honor. The true issue was a Miranda warning. So the defendant's notice said that he did not waive his constitutional rights. That was in the motion to suppress and in his affidavit. And once that has been raised, it is, of course, the defendant's burden to establish that custody. And then the burden shifts to the Commonwealth to establish that a valid waiver, a valid warning has been given. There was no question that
the affidavit didn't reference an interpreter at all or a language issue at all, did it? I'm sorry, the affidavit in support of the motion, my recollection was that it did not specifically mention anything about an interpreter.
That's correct, Justice Singh. There was nothing in the motion or in the affidavit specifically about an interpreter. Of course, it was clear to everyone at the hearing that Mr. De Los Santos required an interpreter. That's right in the docket sheet. And the Commonwealth's own witnesses put that front and center, the notion that Mr. De Los Santos required a Spanish language warning, an interpreter, which is the only reason they called Officer Guillermo to the scene. So it was no mystery to anyone that a valid warning needed to be in Spanish. There was no mystery to the officers, no mystery to the motion judge. And also, of course, we have a supplemental memorandum that specifically raised, the Spanish language issue, which, again, our say was just abundantly clear.
The motion and affidavit not only don't mention the issue of an interpreter, they don't mention Miranda either. And I mean, when I read it, it reads as though the defendant is saying that he was intimidated by the aggressiveness of the officers, and therefore anything that happened after that was not voluntary. And that's the argument also that counsel made at the hearing, was it not? In the closing state argument here.
Yes, Your Honor, that was certainly one of the arguments made at the hearing. I mean, the affidavit says, the motion says the defendant did not voluntarily waive any of his or her rights. And the affidavit is similarly, he voluntarily waived his rights and the statements were not waived. That, in our view, is enough to put Miranda at issue. And once Miranda...
What part of Miranda, do you agree that the defendant waived any challenge to the content of the warnings?
Your Honor, I think that's a little bit debatable. I think Muddy changes the law somewhat. I think that once you have an arguably ambiguous issue, even if the motion to suppress is arguably ambiguous, I think it would have been the Commonwealth's burden to then clarify that. Now, as to the contents of the warnings, yes, that's why I bought a motion for a new trial, because I think that was not raised with specificity. I think there's no question, as indeed the motion judge reiterated in ruling for a motion for a new trial, the last two paragraphs of his ruling on the motion for a new trial revisit and reiterate his findings on the motion to suppress and make abundantly clear that he ruled that the Miranda was given and it was given in Spanish. So in our view,
you agree that the defective warning claim was not raised before the motion?
In the sense, I'm not sure about defective warning. I think the notion, the claim that the warnings, the claim about the specificity of each of the 4 or 5 required warnings, yes, that was not raised.
That's what I mean. Okay.
And so that's why I bought a motion for a new trial on that claim.
So on the issue of whether the warnings were given at all, which is what I understand you to be saying was preserved at the motion to suppress, if the officers at the scene called the Spanish speaking officer to the scene for the precise reason of, for the purpose of translating the warnings into Spanish, even if we assume they didn't speak Spanish, why isn't it a reasonable inference that the officer arrives and once he's heard conversing with the defendant, that what he was doing was giving the warnings? I mean, they weren't just having a random conversation about something else. Why isn't that a reasonable inference?
Your Honor, that may be a reasonable inference, but there's no competent evidence to base that finding on. So I think we need some evidence. It's no different than if the officer had come to the scene and had a conversation in Russian or Moldovan or Bulgarian, and the testifying witnesses are then testifying that, yes, we called this person to the scene and told them to do this, and they're testifying that this happened, but we actually don't know that happened. It could have been, who knows what he said, right? I mean, my client's position is that he was never given the Miranda warnings, and he's maintained that throughout. And we simply have nothing from the Commonwealth to establish a knowing voluntary intelligent waiver. And in Massachusetts, that's beyond a reasonable doubt. I don't believe that testimony from witnesses who cannot understand or comprehend what is being said in the language is sufficient to meet that standard. That's the basic thrust of my argument on direct appeal. We just have no evidence here and it's preserved. And I would just like to emphasize that I really do think Mubdi is relevant to the extent that there is some ambiguity in this motion or motion to suppress or affidavit. Even if you look at the supporting papers, which is the memorandum of support, which expressly states Spanish. Again, everyone at the hearing knew that Spanish was necessary. This is really a failure of proof. It's not waiver.
Let me ask you, if I may ask you a question. Let's say hypothetically that we don't agree with your argument that this was squarely in front of the motion judge, hypothetically. So now it is squarely raised with respect to your motion for new trial, because you claim there that the counsel is ineffective for not raising this exact issue with respect to the Spanish language and the understanding of the Miranda warning. At that point in time, is the judge entitled, well, the judge would be entitled to consider the testimony at the trial, right? In other words, the offer of proof would be here. What exactly should counsel have brought forward at the motion to suppress? Had he brought the issue forward, then Officer Guillermo presumably would have testified there in the same manner that he did at trial. So was the judge entitled to consider that testimony when he was denying the motion for new trial?
I don't think
considering the motion for new trial.
Well, I think Johnson, Your Honor, teaches that what happened at trial is not relevant to what happened at the motion to suppress. But if your question is,
Absolutely. But my question is slightly different. So maybe I haven't made it clear. And that is, or maybe you do understand.
I think I understand. I was just prefacing it with that. Now, I don't think that he would be entitled to do that without an evidentiary hearing. I think that we need an evidentiary hearing because what was said at trial does not broach the issue of what the warnings were. The testimonies at trial was that he testified by translating in his head from an English language card. We don't know what the card said. We don't know what the English language warnings were that were then translated into Spanish. So that would be—
Well, we're pretty familiar with the pre-printed Miranda card that all the officers have in their pocket,
Your Honor,
right?
Well, I mean, there have been cases which I've cited where we have Miranda warnings which are defective. It's not unusual to have defective warnings. And then the next question would be, how were those translated? And this again would be a matter for testimony at an evidentiary hearing, a motion to suppress, where that would be a question, and how do you translate these, Officer Guillermo? And then the fact finder would make credibility determinations about the accuracy of the translation and the completeness of the warning. So that I don't think can be prejudged without an evidentiary hearing. If that were the case, then in most of these cases, it would be a futile exercise to have these evidentiary hearings because the defendant on a motion for new trial would not be able to meet his burden. But I think what Comita teaches is that there is an opportunity to explore, regardless of what happened at trial later, and put the Commonwealth to its burden to see what would have happened on a properly bought motion to suppress. Now, again, it's our view that this is clearly presented, especially when we have, express rulings by the motion judge, on this very issue that for this court to review. But in terms of the completeness and accuracy, there are a lot of open questions which are not answered by the testimony of Officer Guillermo at the trial.
Okay, thank you.
If there are no more questions about the motion for a new trial issue or the direct appeal issue, I can move to the disproportionate force. Or maybe before that, I'll talk about the prejudice, actually, just to wrap this section of the argument up. I don't think there's a credible argument that this testimony, that this statement, that this admission, that this incriminating admission was not prejudicial to Mr. De Los Santos. It essentially confessed to two contested elements of the charged crime of constructive possession, that is knowledge and control. And there's not much else there. Mr. De Los Santos was a passenger in a car that he did not own. The firearm found was in a closed bag. And that's about it. I think that it'd even be difficult for the Commonwealth to show evidence sufficient to go to the jury on these facts. And I cite Commonwealth v. Hill for that proposition in my briefs. So the judge didn't reach that.
So you're saying that without the statement, the Commonwealth could not have met its burden on the case at all?
Well, I think that this was prejudicial, certainly not harmless beyond a reasonable doubt. And I think there's a real question. The evidence is quite thin without this statement, which is why it was repeatedly emphasized to the jury. The prosecutor said that this more than anything shows that he knew about it. So, I'll leave it at that. I can rest on my briefs for the rest of it. I just don't think that there's really a credible argument that this was harmless beyond a reasonable doubt. Moving to the disproportionate force issue, I think the real question here is one of timing. Now, Officer Moody, as he got out of the car, immediately pointed, painted, and aimed his taser weapon at Mr. De Los Santos as he was walking away from a vehicle where he was the passenger. Now, our position is not that it would always be disproportionate to, use a taser, to point a taser, to brandish a taser, but that in the circumstances of this case, it was. There was no opportunity even for Mr. De Los Santos to respond to the officer's commands before he found a red laser light pointed at his chest. And, in those circumstances, based on those facts, trial counsel should have anticipated that. And even though, as the motion judge correctly found, there are no cases precisely on point, the cases that address approaching with drawn guns I think are quite relevant and really speak to how this can turn in what would have been just a Terry stop into an arrest without probable cause. If there are no more questions, I'll rest on my briefs. Thank you very much.
Okay, one moment. I'll just check with my colleagues to see if they have any additional questions for you. And I see they don't. So thank you very much for your argument. And we'll turn now for the attorney for the Commonwealth.
Morning, Catherine Jansen for the Commonwealth. I think what this essentially boils down to is that the defendant is trying to re-litigate this motion to suppress on a different theory on direct appeal. Nowhere in the motion or the affidavit prior to the evidentiary hearing was there any reference to Spanish language being his native language, that Miranda warnings weren't given, that he only understands Spanish. So I don't think that this issue was squarely placed before the motion judge or the Commonwealth to present this evidence before the hearing. I don't think a supplemental memorandum that is filed after an evidentiary hearing is sufficient to raise an issue. And I would suggest that this is different than Muggsy.
Case that says that it's sufficient to preserve an issue for appeal.
I'm sorry, you cut out. I didn't hear your question.
The supplemental memo that you referred to, it's at least sufficient to preserve the issue for appeal.
You know, I'm not sure. I don't know if it is sufficient to preserve the issue for appeal, because I think when you're looking at a motion to suppress and how it's decided and what issues are raised, I don't think that's necessarily fair after an evidentiary hearing to raise this issue that wasn't really fully brought out at the hearing, knowing that we're contesting whether Spanish Miranda warnings were given and if they were actually accurate. And even if
I'm sorry, there was no objection on the part of the Commonwealth to the supplemental memo, was there, or did I miss that?
No, there wasn't. And even if this court were to find that the supplemental memorandum was sufficient to preserve this issue on appeal and whether or not the judge should have considered whether Miranda warnings were given at all, I do think there is a difference between the issue of whether Miranda warnings were given, which the supplemental memorandum only discusses, opposed to whether those Miranda warnings were defective and the content of those Miranda warnings. And I think, so even if a court were to address the issue of whether Miranda warnings were given at all, either in English and in Spanish, and whether it then appeared to understand it, I think the motion judge was based on the evidence in the record that from two officers that, they gave English warnings, the defendant, and up until the arrest, the defendant appeared to speak English, and then basically said, I don't speak English, don't speak English after the arrest, after following subtle commands in English. They had an officer come to the scene. He read from an English card and translated into Spanish, and he appeared to understand that would be sufficient. I would say Perez, which is in my brief, and I would suggest in Perez, contrary to my brother's suggestion in his reply brief, that there was also evidence that in that case there was a Spanish language Miranda card that the defendant read. There were 3 separate issues raised in that case about what would have been sufficient for the Commonwealth to meet its burden, and they decided this issue separately of what testimony from a police officer who doesn't speak that language, saying that another officer gave that Miranda warning in that language be sufficient for the Commonwealth to meet its burden, when that specific issue wasn't challenged about the content of the Miranda warnings. That would be enough. And I would suggest that's directly on point and would be appropriate for the judge to make that finding based on that. Even turning to the motion for new trial issue, if a court were to disagree with the Commonwealth, and specifically whether or not Miranda in general was waived or the content of the Miranda warnings, I would suggest first an evidentiary hearing. The judge made no abuse of discretion not having an evidentiary hearing, because it's the defendant's burden, one, to raise a substantial issue warranting an evidentiary hearing. I would note in defense attorney's affidavit, there is no mention that the defendant does not speak English well, that he only speaks Spanish, that this was an issue. And so I think that's relevant to the judge in one, when he's discrediting the defendant's affidavit saying I only speak Spanish and Miranda warnings weren't given to me and I didn't understand them. So I don't think that was enough to raise an evidentiary hearing. And I do think to some extent, when you're looking at whether or not the defendant would have been successful if he had raised this issue, I do think that although it's not a perfect supplement or a perfect world in looking at trial testimony, I think it's informative to the judge about if if this specific issue had been on notice for the Commonwealth, what would this person have testified to? Obviously, motivations at trial and what you're eliciting are different, but it suggests that you would have been able to, the Commonwealth would have been able to meet this burden regarding Officer Guillermo's ability to speak English and translation.
Well, he did acknowledge that he had not, he'd only translated Miranda warnings, I think under 15 times in the past, and that he was not trained as an interpreter, right?
Correct, but he also was grew up in a Spanish-speaking house.
Excuse me, those would have been issues that would have been explored or could have been explored.
They would have been explored and further fleshed out, but I think based on the testimony at the trial, it's reasonable to suggest, well, one, that he would have accurately translated. He was a native speaker, he grew up in a Spanish-speaking household. He'd been speaking Spanish for 35 years, which I believe was his entire life. And I would suggest that I would look at Jules cited in my brief, which is 464 Mass 478, and there waiver Miranda by Haitian Creole speaking defendant was valid, where the record established the translator was born in Haiti, grew up speaking Haitian Creole, was fluent in it, and there were no evidence that anything particular to the Haitian culture language would have made it difficult for the defendant to understand the translation. I think that's very similar to the facts of what Officer Guerrero had translated before. You don't need to be a certified interpreter to have an accurate translation. And of course, the rights don't have to be translated word for word in a different language. So, but because this issue was never raised, and I don't think it was adequately raised in a motion for new trial to even warrant an evidentiary hearing to know what Officer Guerrero would testify to now, but I do think we have an idea from the motion, from the trial. If the court has no further questions about the Miranda issue, I would just briefly turn to the disproportionate force argument here. I would suggest that this pointing a taser is definitely proportionate force and shows restraint by the police officers rather than drawing their service weapon. This was not a normal traffic stop. You know, there was testimony that upon noticing the ghost cruiser, which basically it's not fully marked, but it looks like a police officer. Both the defendant as a passenger and the driver wide-eyed looked at the police officer and sped away. And then when another police officer had come up behind them, put their lights on, they had their left directional on and they went straight through the light. They did not pull over right away. They went through multiple parking spots. And when they pulled over, before the officers could even get out of the car, both the defendant and the driver had jumped out of the car. And that was, as I believe Officer Mew testified, you know, that was really abnormal and concerning to him for safety because he didn't know why they were doing that. So he pointed his taser and said, get back in the car, and they refused to obey orders. I think based on those facts and circumstances.
Your testimony is that it would have been a show of more force, if you will, had the officers drawn their firearm rather than the taser.
Yes, and I think that's a reasonable argument because, you know, a firearm, when it's drawn, presumably is ready to be fired and it's a deadly weapon. Taser, I would argue, is not a deadly weapon. And, you know, we're always telling police officers to try to show restraint force and to use tasers instead of firearms.
I wasn't suggesting my scenario that an officer pointed the gun. That would be, I think, yet a different. They can approach with guns drawn. They can approach with guns drawn and pointed at an individual, or they can approach with no guns. Or in this case, apparently they pointed the taser at the defendant's chest area.
Correct. And there is a difference between drawing a gun and pointing a gun. And I do understand, I believe that's the distinction you're trying to make as you're approaching.
I'm trying to figure out where the pointing the taser, which I think is something pretty significant, actually. Could be considered pretty significant. Where in the line, in the spectrum of force would you put that?
I would put pointing a taser below drawing a gun, because drawing a gun takes no time at all to pull it up and shoot somebody in a split second. And in this situation, we're talking about an officer making a split second decision for his safety. And so officers aren't required to gamble with their life. And I think a taser, whether drawing or pointing a taser, so pointing a taser opposed to drawing a gun and not pointing a gun, I would say pointing a taser is less intrusive and more proportional than taking out your gun out of your holster, ready to use, especially where a taser is not deadly. It's made, and I would, you know, as the U.S. Supreme Court has said in Catano, it's made to incapacitate and not harm. A gun is used to kill. So, I mean, I think that can't be divorced from the fact. And I would suggest, although the cases I cite in my brief deal with drawing guns, because there really is not case law that my brother or I could find on the taser issue. I would suggest, and so some of those, because drawing a gun, I think, is more intrusive than pointing a taser. Each one of those cases, Torres and Diet, I would say, we can see they have like a little bit extra fact more than this case, and I do recognize that. But I would also, point to the fact that, initially failing to stop, opening doors really quickly, that's Torres, and just, evading erratically. Those are all factors. When you don't know what's happening, a traffic stop is extremely dangerous for a police officer.
The defendant was the passenger, right? He wasn't suspected of a crime. He was walking away at the time that the officer pointed the taser. So how is that proportionate given the circumstances of the defendant?
I would say it's not, he doesn't have to be suspected of a crime. I think based on the testimony that both the defendant and the driver, so not just the driver behaving erratically, but when they both see the police officers, they're wide-eyed and they both react to the presence of police officers before they even put the lights on. And then the initial action of both of them throwing open their doors and both going immediately leaving the car before the officers even get out, not to go in the convenience store. I think that puts officers on heightened notice about that there could be a danger. So I think it doesn't matter that he's not the driver.
Danger from both individuals walking away from the police.
I think it's danger when you're evading police kind of erratically and acting kind of I don't know how my words are missing from me right now, but I think it's dangerous when you're behaving unexpectedly and it's not what people expect, and you don't know why are you leaving the car that fast? Are you coming at me because you have a weapon? I do have a weapon in the car. I don't know. And officers are you can't divorce the fact that this is a split-second decision that officers have to make. And I would suggest that if the officer had drawn his gun or pointed a gun, maybe that would be inappropriate in these circumstances. But I think a taser is not. Officers don't have to gamble with their safety when they're doing a traffic stop and something erratic like this happens. That really heightens their senses about some perceived danger. And if the court has no further questions, I would rest on my brief.
All right, give me one moment and I will confer with my colleagues to see if they have any follow-up questions, and I see that they do not. So thank you for your argument. Thank you.
Live and recording.
Okay, thank you very much. Good morning. I'm going to begin by introducing the panel to you. My name is Ariane Vuno. I'm joined today by Justice Young Shin and Justice Sabita Singh. The name of this case is AC versus CH 2021-0687. And as you both know, the case is partially impounded. Each one of you has 15 minutes to present your argument. There is no rebuttal in the appeals court. We appreciate your utilizing this remote platform for your argument today. Upon occasion, we have some small technical difficulties. We haven't had any yet today, so I don't want to jinx it. But if we do, they get resolved usually quite easily, and I can assure you that no one will lose any time as a result. All right, with those preliminaries aside, let's begin with Attorney Pickett. You have 15 minutes to present your side of the case.
Good morning, Your Honors. My name is Karen Pickett. I represent the appellant CH in this matter. As Your Honors know, this matter arises out of CH's former attorney AC obtaining a harassment protection order against her, a temporary one in the Leominster District Court and later an extension in the Worcester District Court. We've raised a number of both substantive and procedural issues as to why these orders must be vacated. I'd like to start, I know Your Honors are familiar with the record, but as you know, I inherited the case recently and I was sort of shocked by it, and I went through the record as carefully as I could to figure out exactly what the evidence was and what the allegations were. And I think knowing what those things are before we discuss the standards is important, and I'll try to touch on it briefly.
Okay.
As your honors know, AC filed a complaint for temporary HPO. And that complaint said that there were 3 dates where the harassment occurred: June 17th, 2001, June 25th, 2001, and again, June 25th, 2021. If you read the affidavit, there's all sorts of information, I would assert privileged information being put out. But when it comes to the allegations of harassment, he alleges that on June 7th, and I don't know if that's a typo because above it says June 17th, CH and her husband were on a Zoom call with him and his associates. CH screamed at them and was questioning their competence. The next incident he alleges is that there was a Facebook post, he doesn't say when, and as we know, it was never produced into evidence, where he says they were calling us thieves and making up things. And then finally, he said that CH called 3 times and emailed and Facebooked his secretary, and these were presumably on June 25th, quote unquote, trying to speak with us. So that was the basis in the complaint and the affidavit to try to get the emergency HPO. As you know, at the emergency HPO hearing, the court asked AC about these things and said, have any of these contained personal threats? And he responded, not so much personal threats, Your Honor, but knowing what I know in her history, Your Honor, I'm in fear of this woman. She has numerous criminal charges against her. And the court cuts him off and says, so you think she could physically harm you or members of your staff? And AC says, definitely members of my staff. When the court questioned about what the 3 instances were, he said, the Facebook posting, numerous calls, numerous messaging. Again, based on our history, I want to make sure we're well protected. As you know, the judge entered that emergency TPO, and included on there was a written notation as, in addition to the standard sort of no contact requirements that say no internet or social media post comments or contact with the complaining witness office staff, no contact with employees or family of plaintiff. We know that there was, the case was transferred to the Worcester District Court, and if time allows, I'd like to, at the end, I'll go into some of the procedural issues here that also require vacating the HPO.
Can I ask you a question? In addition to your position that there was not sufficient evidence to issue this prevention order, is it also your position that it was simply too broad because it included this AC staff and secretary, and also it was a prohibition with respect to any internet transmissions?
Yes, Your Honor, and that's raised in the briefs themselves. First of all, we argue that under the 250 AD, the alleged threats, which I assert there were none here, not let alone 3, but the alleged threats have to be directed to a specific person. And, you know, AC himself said that he didn't feel threatened and somehow was saying his staff felt threatened. Again, not sure why, because in his affidavit, he said that they were calling him to try to reach him because apparently they had received his letter, his disengagement letter. And perhaps that was confusing to them. Perhaps they needed additional advice, but there's nothing wrong with reaching out to your lawyer per se. So, and he never said, wrote, or presented evidence of any threats to the secretary as such. And then, so we say he doesn't have standing to assert any claims on behalf of his staff. And we also say that obviously saying that my client can't make internet posts or social media posts that weren't directed at him anyway is overbroad and is a violation of the prior restraint rule under the First Amendment. We know at the extension hearing, not too much was added, although he did say after my clients received the temporary order, they apparently called the Leominster police and claimed that they were worried that he was going to try to take his children away. Again, nothing in the nature of a threat or nothing directed at him. So with that said, and with that evidence, again, as we know, there's no exhibits, there's no affidavits besides his, there was no other testimony besides his. he has the burden of proof here to show that harassment occurred under Section 1 of 258E. And that statute specifically defines harassment as 3 or more acts of willful and malicious conduct aimed at a specific person committed with the intent to cause fear, intimidation, abuse, or damage to property, and that does in fact cause fear, intimidation, abuse, or damage to property. As your honors know from my presentation, there's no evidence that my client, showed up at the office or had any, contact besides trying to perhaps call or communicate with her former lawyer. Everything that's alleged is in the nature of speech that she made on the internet and speech she made in trying to contact her lawyer who had just disengaged. From AC's brief, I take it that he doesn't argue that anything my client said constitutes fighting words. And instead, he argues, as he must, because under O'Brien, he has to show that words constitute a true threat. And so he's arguing under the true threat doctrine, which is sort of an exception to the First Amendment protections, that there were 3 direct threats here under the statute. I'd like to just read what the Supreme Court has said is the definition of true threats. And this is in the case of Virginia v. Black. True threats encompass those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. There's absolutely, and I can't even try to fathom where the argument is, to tell you the truth. It seems as if, frankly, my assessment of the case is that there was some kind of falling out with the client. The lawyer was upset that she had taken to social media. He was upset that she called him a thief. And there are other avenues that the lawyer could have pursued. For example, if that wasn't true, he could have tried to bring a defamation case against her. But what ended up happening here, Your Honors, is that he abused the HPO process and went into court. And now you see claims that his former client, CH, committed 3 true threats. And there's just no evidence of that. And I think that alone is a reason to vacate this, because my clients had to run the gauntlet here and defend herself against something that frankly is just doesn't even come close to meeting the standard. The reason I wanted to assert the substantive issues first is because I don't want this to go back on some kind of procedural issue and have it brought up again. I think it's clear that the evidence doesn't support the HPO, and when that happens, this court should vacate it and order the district court to vacate it so that it's taken off my client's record. If Your Honors don't have any questions about the substance, I'd like to quickly cover the procedural issues if Your Honors decide that you want to examine that route as well. We know that the order on the temporary order was served on my client's husband on June 25th, the date of the hearing. If you look at the order itself, there's a couple different things on there. Where in the form it says next court date, it says June 9th, 2021 in Leominster, Mass. Then there's handwritten notes on 2 parts of the order where it says next court date is in Worcester, July 9th, 2021. From what we can tell from the return of service, the officer said the husband picked up the order. There's no indication that there was a summons ever issued in the case. And there's no indication that the complaint was also served with that. Interestingly, on June 28th, there was the official order transferring the case from Leominster to Worcester. The judge said, or the regional judge said, following receipt of this transfer order, the Leominster clerk shall provide a copy of it to the parties. Upon receipt by Worcester District Court, the clerk magistrate there shall take whatever steps may be needed to schedule the next case event and so notify the parties. On July 1st, there was a notice of a virtual court hearing sent to my client's name at the address she has in Wellesley, but instead it was indicated on the docket that it was sent to Watertown, Mass. 02471. When everywhere else in the record, you'll see that her address is Wellesley, Mass. 02481. We know that that AC showed up at the court date on July 9th and then participated by Zoom. And those orders were, after that, the orders were delivered to my client. As your honors know, under Section 9, once the emergency TRO issued, the statute, Section 9, requires that the clerk transmit 2 certified copies of each such order and 1 copy of the complaint and summons forthwith to the appropriate law enforcement agency, which, unless otherwise ordered, shall serve 1 copy of each order upon the defendant, together with a copy of the complaint and order and summons. And then the law enforcement agency shall promptly make its return of service to the court. I would suggest that the record shows that this did not happen. I know that there's been some sort of allegations in the appellee brief that somehow, my client showed up there anyway. Again, there's nothing in the record to suggest that. I've had a number of—
Counsel, could I just interrupt you? You don't
Sure.
think we need additional factual findings to resolve this question?
The question of
whether she was properly served. I mean, there's certainly an issue that arises on the record, but we don't need additional factual findings to conclude that she was never served.
Well, we know she was served, Your Honor. She was served with the temporary order, but you'll see there's
She
no—
wasn't served with that she wasn't served with the summons and complaint and the notice of the hearing, which is what she's arguing on appeal. You're saying that we can decide those questions on the record that we have without additional factual findings from the judge?
Yes, Your Honor, I believe you can, because if you look at the docket, you'll see that there is no summons in the docket, and the return of service specifically says the order was served on my client's husband, who accepted service on her behalf. I don't think we need additional factual findings when the record itself shows that there was no summons. And in any case, as we know, the transfer order required that she be served notice by the Worcester District Court, and the docket itself shows that notice was sent to the wrong address. So regardless of what's raised in the appellee brief now, there is nothing on the record. I can't imagine a judge sitting on a Zoom hearing. I've been in several in the last couple of years in district court, where he doesn't say, who's here, and then sees somebody on the screen that allegedly says DH or whatever the appellee says, and doesn't inquire further. I would suggest that doesn't happen. It's very clear what happens in Zoom hearings in district court, and the judges do the right thing and ask, who's there. And the judge specifically found that my client did not show up. And again, I think the record shows quite clearly that my client was not served. We know that she filed a notice of appeal almost immediately after being served with this order. And, frankly, Your Honor, if you thought that it should be sent back for findings, I would argue that you should look at the merits, because I don't believe that my client should have to go back to district court and, even if properly served, defend against these allegations when she wasn't even there in the first place, and there wasn't enough evidence, let alone she wasn't able to challenge it. But the evidence that he presented on its face does not meet the standard. Thank you, Your Honor, unless you have further questions.
I'll check with the panel, and I see no further questions from either one of my colleagues. Thank you very much, Attorney Pickett.
Thank you.
Thank you for your argument, and we'll turn now to Attorney McMahon.
Good morning, Your Honors. It's good to be here with you this morning on this issue, this case. My sister pointed out some points in the order, and I'd like to also point out several points on the order, at least procedurally. On page 19 and page 20, and also page 33 and page 34 of the record appendix, and also the addendum to our brief on page 41, 42, 43, it's the same document. It is the abuse prevention order, the same order that was served on the, CH by the police. And in the order is several places indicates the next court date, which would be July 9, 2021 in the Worcester District Court. In the boilerplate of the order, and I think this is important, the boilerplate says at the very top, for use during COVID-19 emergency. Near the bottom of the order, it says if either the plaintiff or defendant has questions about the hearing or the order, contact the court by phone at the courthouse phone number, and then in all capital letters, it says before the date of the hearing. If you cannot reach the court, please call the trial court helpline, and then there's a number. Then there's a further caveat warning at the bottom of the order. It's boilerplate, and the reason why it's the boilerplate, it's for every litigant and every attorney, and apparently in this case, both parties are both. It says the above order and any subsequent orders have been issued by a judge. A hearing on whether to continue and or modify the order will be held on the date and time indicated on the order. The hearing will be held through a telephone conference call. If listed, the call-in number above, use the password, and if not, and it goes on further to instruct the litigants to call the clerk's office. So the question is asked in the appellant's brief, how did AC know to go to the court or go on? He called, he followed the instructions that are given for use during the COVID-19 emergency. Now, if they didn't read the order and didn't follow the directions and either got lost, decided not to call, decided not to participate, well, that's on them. They had the opportunity to appear. They had the opportunity to present whatever they wanted to present. And the warning further on here is that it says that the order may be continued or extended if it's not opposed. So what do we have? What are the facts here? AC showed up in Worcester, was told he can't go in the courtroom, so he went somewhere else, and he got online because he brought his laptop with him. How do you know to do that? Because the clerk's office in Leominster told him to. He goes there and he presents his case. Now, it's my sister mentioned something about practice on Zoom. It's been my practice, such as it was in this court, is that the someone preliminarily lines up who's there, the litigants who are here, and then the case begins when they announce who they are or if they're there. It begins on time. If you're not there, you're not there, and it goes on. Now, when the court looks at these documents, especially the order is very clear. The instructions on it are very clear. And they were served before the hearing date. That is very clear. So if they don't call the clerk's office to clear up any ambiguity, which in two places it's offered, and on every other page, which I've already pointed to, that are in the appendix and also in the addendum.
Let me just clarify one thing. The docket does say that on July 9th, the order that was entered on June 25th and extended to expire on July 8th at 4 p.m. That was entered and extended to July 8th, 2022, after hearing at which plaintiff was present and defendant not present. Right? Is that what the docket says? Okay. And you don't contest that, right?
No, don't contest that.
Okay.
So anyhow, procedurally, I mean, the instructions are clear to every litigant, every lawyer, every person involved in a harassment prevention order. Now, we cited a case in our brief. It's CRS versus JMS, talking about the appeal at each step procedurally. Here, CH, according to the holding in the CRS versus JMS case, that's 92 Mass App 561. I know a little bit about that case because I argued it, and I was on the bad end of that case. Basically, what that case holds is that there is no appeal on the emergency issuance of the order. So I think CH is out on that. This court's already said you don't get to appeal an emergency HPO. Your opportunity is at the first hearing with notice.
Well, maybe we can move to the what is certainly we would all agree is before us, which is the fact that CH has appealed from the order extending the prevention order, and there was no additional evidence presented at that hearing, was there?
Well, there was. I mean, AC was there, and he had his associate with him, and they were on Zoom, and they answered questions that the court asked because apparently CH either didn't show or didn't light up.
Okay, so back to the evidence that was presented. When you say they answered questions, was there any additional evidence, additional exhibits, or anything of that nature introduced at that extension here?
There were no exhibits. They were actually they were talked about, but not issued into evidence. And I think what typically happens.
That leads to another question. So what are we to make of those exhibits if they were not introduced at the hearing?
They were described nonetheless.
Well, can you describe for me in a little more detail what the phone call was, for example, that was allegedly placed by CH to AC's secretary?
Yes. Well, what he did was he described what he knew, and I mean I could read the transcript. I mean the court obviously.
Well, no, I read the transcripts as well, but what I couldn't find in there was any actual threat. Perhaps some rudeness or overreacting, I suppose. I
would call it that. I would call that at a minimum. Rudeness and overreacting and posting on social media that he's a thief and all kinds of.
Could you point to me where there was any threat? What the actual words were that constituted a threat to either his secretary or himself?
I think that what he did not quote a particular threat, except that he says, knowing what he knows of the history of CH, that he feels threatened, and he mentioned that there was other actions and criminal actions that he knew about. Now, the court didn't ask for further information, so he didn't offer further information.
Counsel, you're not suggesting that because the defendant didn't appear, whether it's because she didn't have notice or not, putting that aside, you're not suggesting that relieved your client of his burden, are you?
No, I'm suggesting that the court was satisfied from what they saw.
All right, and we're reviewing that on appeal.
Right.
So let me just cut to the chase. Where are the three true threats in this record directed at your client?
Well, he mentions the events that happened on the 17th and the 25th, the two events. I mean, the record, the transcript is what it is. I mean, I can't magnify it, and obviously the appellant wants to minimize it, but the court had the opportunity to hear that and then see, at least by Zoom, and was able to weigh what the court felt was satisfactory enough to issue this. And without any opposition in it, the court has a right to extend.
Well, no, the judge has the right to extend, the judge has a right to extend when there's a finding of 3 separate acts of harassment. And what we're trying to pin down here is the 3 separate acts of harassment against AC, not other people as well, because of course we have to talk about one victim here, not multiple victims, correct?
Okay. All right. So you certainly have the issue of the constant phone calls. You certainly have the issue of the posting on the social media, and you also have the issue of her going off on him when, as he said it, when they initially told him she doesn't have a case. Now she doesn't.
So I understand those are three contacts, but for the sake of repetition, where's the actual threat? And so, for example, the posting on Facebook, which we don't have, in which he's allegedly called a thief. Where's the threat in that?
Well, the threat is in the harassment component. It's not stopping, it's accelerating.
Okay.
All right. So anyhow, Your Honors, if I may just say that the returns of service by the police are typical returns of service. It doesn't, that they put down the paperwork, they call the whole thing in order, and having done dozens of these, probably hundreds, it's always the same. They call it the order. The police call the paperwork the order, because to them, the important part is the order. That's what they're tracking. They certainly served CH with plenty of time for CH to call the court and to ask what courtroom it's in, what courthouse it's in. Oh, I don't even have to go to court. I just go on Zoom. Had that opportunity, was certainly given that warning.
What do you say about the wrong address?
Well, Your Honor, the wrong address, according to them, was just a subsequent notice. In other words, if she didn't get it, she still has this that says to call in. She still has the boilerplate on the bottom to call in. So I don't know what to say about that. I don't know whether they received it back in the mail, made a phone call. I have no idea what the clerk's office did. But what I do know is that with the order, and they agree they received the order, the boilerplate in the order instructs them to call in before the hearing date. So the point is that they have notice. They're asked to call in before 9 a.m. There is no insufficiency of notice. There may not be abundance of notice, but there's plenty of notice and instructions as to what CH should do and expect. There's no appeal of the initial emergency HPO, and the judge asked particular questions during the second hearing. The judge received answers. The judge extended the order, which was her right to do. If there's no further questions, I'll rest on the rest of the issues on the brief, which I think we did. We sufficiently addressed each issue in the brief. Thank you very much.
Okay, thank you. One moment. I'll check with my colleagues to see if they have any follow-up questions. And I see none. So I want to thank you both very much for your arguments. We know that these cases are always somewhat emotional. So we appreciate you presenting your arguments the way that you did. And
We're live and recording.
all All right, thank you very much. I'm going to call the fourth case on our list today, which is Geraldine Griffin versus Harry Kay. The number is 2021-0302. I'm going to begin by introducing the panel to you. My name is Ariane Buno. I'm joined today with Justice Seok-Young Shin and Justice Sabita Singh. As you know, you each have 15 minutes to present your argument. I will remind you that there is no rebuttal in the appeals court. So upon occasion, we may have a technical difficulties. So far this morning, everything has gone smoothly. If we do, we resolve them quite quickly usually, and I can assure you that no one will lose any time as a result. All right, so let's begin with Attorney Rivers, who represents Geraldine Griffin, correct?
Yes, Your Honor. Thank you and good morning. May it please the court. My name is Attorney Robert Rivers, and together with my law partner, Jessica Dubert, I represent the appellant, Geraldine Griffin. There are three claims of appeal that are set forth in appellant's brief. The first is that the terms of the parties' surviving separation agreement precluded modification of Mr. Kay's alimony obligation. The second claim on appeal is that even if Mr. Kay's alimony obligation was subject to modification, the trial court's modified alimony judgment did not achieve a, quote, fair balance of sacrifice, close quote, based upon all of the evidence at trial and application of the established case law. And lastly, we contend that the trial court's contempt judgment failed to adjudicate and clarify the alimony arrears due and owing to Ms. Griffin based upon the cost of living adjustment formula that was set forth in the parties' separation agreement, and the trial court's express findings regarding the, quote, gross earned income, close quote, of Mr. Kay for the COLA calculation purposes. With respect to the first issue, I would like to point out that the law is very well settled in the Commonwealth that as a general proposition, the parties, unless the parties expressly provide otherwise, their separation agreement will be held to survive a subsequent divorce decree incorporating by reference the terms of that agreement. And that's in the De Cristofaro case from 1987. And in fact, going all the way back to 1969 in the Hills versus Scheer case, the court has made clear that merger is not lightly to be presumed. In this case, I would contend that when you read the four corners of the separation agreement that the parties entered into, there is an absence of any language whatsoever referencing the word merge or merger, such that the conclusion that was achieved by the trial court that the separation agreement was subject to modification was clearly erroneous. The agreement spells out in paragraphs 13 and 14 the status of the agreement with respect to its future modifiability. And those two paragraphs I would submit to the panel are the most operative and relevant provisions to the issue that's before the court. The only recognized way in which the alimony provision could be modified by the court was if it was established that there was a material, negative, and involuntary change of circumstances involving either of the parties. The trial judge made a specific finding that Mr. Kay's retirement from employment did not meet that definition. Nevertheless, the trial judge found that there was a merger of the retirement provision such that the court was able to modify that provision. And we contend that that was a clearly erroneous provision. And I also would like to point out to the panel that when you look at paragraph 13, the parties themselves went to great lengths to include intention language, as I would call it, to identify exactly what it is they were doing with respect to the future modifiability of their agreement. If you look at paragraph 13, it says, the purposes of this paragraph are: one, to protect both parties against any attempt by the other party to vary the terms of this agreement as to interspousal support and property division after the entry of judgment nisi and/or final judgment.
The
I don't
agreement
think-
has specific provisions for the situation of retirement, correct? And that's what this was premised on. The judge ruled on the basis of paragraph or Exhibit A, paragraph 7.
Right,
The normal
Exhibit A,
retirement.
Exhibit A, paragraph 7 says that the parties agree to review alimony upon the normal retirement of the husband. However, there's nothing in paragraphs 13 or 14 that captured that language as being subject to modification or being a merged provision
What
in
does
any
that
way, shape,
language
or form.
mean when it says that the parties agree to review it? What does that mean? What does a review mean if it does not mean that there could potentially be some modification?
Our
on normal
contention,
retirement?
our contention is the words mean exactly what they say, that the parties agreed amongst themselves to revisit and review the alimony upon the husband's normal retirement. And I
So
think
that this was something that could be done only by the parties, but not by the court? Is that your contention?
it's not only my contention, Your Honor, but if you look at paragraph 14 of the parties' separation agreement, the parties actually said, except as set forth in paragraph 13 above, if any judicial judgment should be sought or entered with respect to alimony and/or support for the wife or the husband, or division of property pursuant to Massachusetts General Laws, Chapter 208, Section 34, neither party will seek to have such judgment or any modification thereof provide for payments or property transfers different in any way from those provided for in this agreement. So if the
Right, and
parties had,
the retirement provision begins with the words notwithstanding anything to the contrary. So
It does.
let's assume that the agreement is ambiguous as to whether the parties intended for the retirement provision to be merged. Why isn't the assented to motion for relief from judgment and the amended judgment essentially conclusive proof that the parties intended that it be merged?
well, for two reasons. One is that in order to be consistent with the law, it must be an express provision or an express agreement that there's a merge provision that's subject to modification by the court. Nothing in the assented to motion for relief from judgment referenced the word merger at all. So I would contend, first of all, that nothing in the assented to motion for relief from judgment modified the existing agreement regarding merger and survival. Those paragraphs.
It says that the motion says the terms of the agreement were to survive, not be merged, subject to paragraph 13 and the retirement provision. And then the amended judgment says that the agreement is not merged into this judgment, subject to the same two provisions. That seems to me to be pretty clear that the agreement survives except for the two provisions that the parties agreed would be merged, which includes the retirement provision.
First of all, I don't think that a judgment of the court under the Moore case can modify the parties' agreement.
No, I'm assuming a world where the agreement is ambiguous. Okay, so let's accept that it's ambiguous whether the parties intended for the retirement provision to be merged. Then the court can look at what the amended judgment says and what the assented to motion says. And why isn't that pretty clear that the parties did intend for the retirement provision to be merged?
Because in order for that to be clear, they would have had to have also modified paragraphs 13 and 14 of their separation agreement, which they never did. The only way in which they could modify the survival language in paragraphs 13 and 14 was pursuant to the provisions of paragraph 18 of their separation agreement, which required an agreement signed by the two of them and acknowledged or notarized by each of them. That didn't happen in this case. And paragraphs 13 and 14 stand alone as being the operative provisions regarding the status of the agreement moving forward. And so also in reference to the arguments that have been made that somehow the judgment provided for merger, as you know from the Moore case involved a discrepancy between a separation agreement that by its terms survived in a court judgment of divorce that provided that provisions of the agreement merged. And in the Moore case, the Supreme Judicial Court made clear that in a dispute, so to speak, between an agreement and a judgment regarding survival or merger, it is the agreement that controls, not the court's judgment. So even if the court entered its amended judgment of divorce, the terms of that amended judgment of divorce cannot control over the clear and expressed language in paragraphs 13 and 14 of the agreement. And the last point I'll make is that if you look at I believe it's page 7 of the brief that was filed by the appellee acknowledges that the Exhibit A to the agreement and the boilerplate provisions of the agreement are standalone provisions that are separate and distinct from one another. So any suggestion that the language of notwithstanding anything to the contrary being somehow to modify paragraphs 13 and 14 is inconsistent with an admission I believe that the appellee has already made in his brief that was filed with the court. Secondly, I would like to address the issue about the fair balance of sacrifice argument. And I know that that issue was briefed in detail, but I do want to just point out to the panel that when dealing with an agreement that predates the enactment of the Alimony Reform Act in March of 2012, the only provisions of the Alimony Reform Act that apply retroactively to a case that predates its enactment are the durational limits. The retirement provisions set forth in the Alimony Reform Act and the cohabitation clause provisions in the Alimony Reform Act do not have any retroactive application. So because this agreement predated the enactment of the Alimony Reform Act by many years, the Alimony Reform Act does not apply to the analysis that was required to be undertaken in this case. The case that basically sets forth the analysis that needs to be employed is the Pierce case, which was cited and briefed extensively in our brief. The fair balance of sacrifice standard, I contend, was not properly applied by the trial judge in this case. The evidence that was admitted at trial showed that Mr. K's lifestyle and his resources, even upon retirement, based upon a pro forma financial statement he submitted, were going to be many times greater than my client's lifestyle. In fact, I believe he budgeted his post-retirement living expenses at almost $450,000 a year, including over $84,000.
That's because of his new wife's financial situation, right?
It is. And while it's true that new spouses don't have an obligation to support someone's former spouse, the case law is clear, Sylvia in the Cooper case, that the court can consider someone's second spouse's financial resources in determining what ability to pay a person has with respect to their ongoing alimony obligation.
Those cases do say that, but what I found interesting is that they both involved appeals by the payor spouse, arguing that the judge improperly considered their new spouse's finances and ordered too much, right? That the payor spouse is arguing, I didn't have the ability to pay, and the judge erred by considering my new spouse's financial circumstances in considering my ability to pay. Do you have any case that says arises in the situation where the appellant is arguing the judge ordered too little?
I do. I believe the case that would be on point would be the Pierce case itself. When you read the Pierce case, you'll see that both the trial judge in that case, as well as the appellate court, took into consideration the financial resources of Mr. Pierce's subsequent spouse in determining the fair balance of sacrifice argument. So I would contend that the Pierce case itself stands for the proposition that the financial resources of Mr. K's
I
subsequent
mean, I
spouse
think that's
could be
right. I
considered.
think it does generally. I think it does generally, but what amounts to an error in this situation where the judge is allowed to consider the new spouse's financial circumstances? That much is clear from Pierce. But I mean, your argument seems to boil down to the judge didn't give that enough weight. But how is that how do we assess whether that's an error?
I think it's an error when you look at what the amount was that was ultimately ordered. $480 a week was a 72% reduction in my client's alimony at a time when Mr. K was admitting that he was going to be living a lifestyle of almost $450,000 a year of living expenses, and that the result was an abuse of discretion and was clearly erroneous based upon all of the evidence that was admitted during the trial. I see my time has expired, so I don't want to go over my time.
Correct. Thank you very much for your argument, but I will check to see if my colleagues have any additional follow-up questions. I see none, so thank you very much. And we'll hear now from Attorney McBrien.
Thank you.
Good morning, Your Honors. My name is Maureen McBrien. I represent the appellee, Harry Michael K., along with my partners, Wendy Hickey and Alexander Jones of Brick Jones, McBrien, and Hickey. Today, you're tasked with determining whether my client's alimony obligation was modifiable or not. And presuming it's modifiable, whether the judge's result achieved a fair balance of sacrifice between the parties. That's the two primary issues on the modification. The crux of the appellant's argument is that the alimony is non-modifiable. That is simply incorrect. The intent of the parties is clear and has been clear since their divorce in 2004. In their separation agreement, they agreed that the entire agreement survived, except for two caveats, pursuant to which the alimony would be modifiable. On page 6 of the agreement, it states that in the event of a material negative and involuntary change in the circumstances of either party, that party may seek to modify the provisions of this agreement most affected by that change. That is not the provision under which Mr. K sought relief. Instead, he sought relief under the provision at Exhibit A of the alimony exhibit of their separation agreement at paragraph 7 that states, notwithstanding anything to the contrary, the parties agree to review alimony payments upon the normal retirement of the husband. When the divorce judgment arrived, it said the agreement survives its entirety. The attorneys said that's incorrect. We need to modify it. Not modify it, we need to correct, in fact, a clerical mistake is what it was called. It was not a modification, it was simply an adjustment to the judgment by agreement of the parties. You'll see it was an assented to motion to address the judgment which provided for survival because it was incorrect. It did not reflect what the parties intended or what they agreed to. Why would they have done that had they intended the entire agreement to survive, including the alimony provisions upon retirement? That interpretation is illogical. The entire argument in this regard is negated by the amended judgment of divorce nisi, which is at the record appendix number 43, which the judgment was amended to reflect that the agreement survives subject to the limited change of circumstances provision in paragraph 13 on page 6, and an alimony review upon the defendant's normal retirement age as provided in Exhibit A, paragraph 7. The appellee's interpretation would have you ignore the words subject to and render them completely meaningless. If they don't mean that this provision is modifiable, then I would ask you, what do they mean? While this is a plenary review as it's an issue of law, 2 judges below agreed with the interpretation. Not only did the parties ratify their mutual intent regarding a review upon retirement in 2004 by amending their judgment by agreement, when there was a motion to dismiss Mr. K's complaint for modification before Judge Peterson, she too, in a denial of the motion to dismiss dated September 20th, 2017, agreed that the intent of the parties was that alimony would be reviewable upon retirement and that the issue in and of itself merged. Again, following a full trial on the merits, Judge Rivers said the parties' separation agreement and amended judgment of divorce nisi clearly articulates the parties' intent regarding the possibility of a future modification of Mr. K's support obligation, and reiterated what Judge Peterson had said. Two judges below agreed with this interpretation, and the parties themselves took steps to make sure that their intent was accurately reflected in the amended judgment of divorce. Now, another argument made by the appellee is that review upon retirement didn't afford the court the ability to review it. It only afforded the parties as between themselves to review it. Well, one, as between themselves does not exist anywhere in that language. You can't simply insert it. Further, it defies logic that Mr. K would have agreed to give Mrs. K and Ms. Griffin a trump card with respect to whether his alimony obligation could be modified upon his retirement if he was otherwise not able to obtain court review. And I'll remind you that at the time of the divorce, this was in 2004, this was a 62-38% division in Ms. Griffin's favor. If you're looking at basic contract principles, what would the consideration have to be consideration for him to give up his right to any modification or review of his retirement? His alimony obligations upon his retirement. There's no consideration in the agreement for any such provision that he would have ever had agreed to. And in fact, he did not agree to it. It was their intention that the obligation would be reviewed upon retirement. He began to discuss his retirement or his desire to retire in 2011 with Ms. Griffin. It went nowhere. He then resurfaced and said, I really want to retire in or around 2017. He's a practicing attorney for 42 years. He was losing his client base through no fault of his own. And it was time for him to retire. He gave her ample notice. She was not receptive. As a result, he filed this complaint for modification. With respect
to the second argument.
Yes, with respect to the result, and I agree, it's a shared balance of sacrifice argument. That is an abuse of discretion standard. There's lots of deference afforded to the trial judge in her opinion in that regard, and it achieves the very shared balance of sacrifice one would expect to see when a payor retires, notwithstanding his retirement and the fact that he has zero income. The alimony obligation continues indefinitely at the rate of approximately $25,000 per year. In addition, he is still required to pay the Medicare supplements, which total over $5,000 a year, and he's required to maintain $1 million of life insurance, which costs him $8,100 per year, such that if he predeceases her, she gets $1 million. All of that factored in to the shared balance of sacrifice. And is an acknowledgement that yes, Ms. Griffin continues to need alimony, which is why it continued, notwithstanding his retirement. The ability to get the meet his financial obligations post-retirement comes from his post-retirement income, which the judge determined to be a 4% return on his retirement assets, plus a Social Security, such that the stream of income from what she is paying paying alimony in his retirement comes from assets that some of them were divided already in the divorce, and his Social Security. So I would submit to you that it achieves the very fair balance of sacrifice that we would contemplate in such a circumstance. And the fact that they have disparate lifestyles is in large part due to Mr. K's remarriage. He still has expenses. His current wife has no obligation to pay his alimony obligation. There is a prenuptial agreement between Mr. K and his current wife. That's largely irrelevant.
So Did the judge consider his current spouse's finances at all in modifying this support order?
Well, there was reference to the current wife's finances insofar as they're splitting expenses for the homes. So she did look at his expenses are less as a result of the fact that he's cohabiting with his current wife. It does impact in relevance somewhat to his ability to pay, notwithstanding the fact he has no earned income, because his expenses are reduced by the fact that he's married to someone who's also contributing to expenses. But otherwise, no, it wasn't a factor.
And you're saying that is not erroneous because the judge does not have to take into account the lifestyle that the payor spouse enjoys on account of a new spouse?
So lifestyle is certainly relevant, but it's not dispositive. The tables have turned a little bit in that Miss Griffin enjoyed a greater lifestyle than Mr. K post-divorce. She was in a large home in Nantucket. He was in a one-bedroom condo in San Francisco. He gave her $800,000 more in assets than he had. His circumstances certainly changed for the better over time, and perhaps we don't know where her money went. In fact, that was a question. But the judge did the best she could under the circumstances. She didn't, including everything. She did look at the fact that he has a certain lifestyle and she has a certain lifestyle. Much of his lifestyle and the country clubs and such was attributed to his wife and to business expenses he was legitimately incurring to maintain his clients. But overall, given the totality of everything, that was looked at as a factor in conjunction with the rest of the situation. The fact that Mr. K retired in good faith, attempted to involve her, that she was selling her Nantucket property and her 89% of the expenses on her financial statement were attributable to the Nantucket property. She didn't know where she was going or what her expenses would be. And let's remember, this obligation is still modifiable in the future. So my client, Mr. K, is on the hook now for an indefinite alimony obligation, notwithstanding the fact that he's retired. Miss Griffin, we don't know her situation. If worst case scenario, she becomes a public charge, she can still file a complaint for modification. So the judge looked at everything holistically. And I think when you, just very much like the Pierce case, in the Pierce case, which is operative here, the payor there was also remarried to a woman who was contributing to his expenses. That was looked at. That was not dispositive, but it was certainly relevant. So I believe that it was
Pierce involved. The issue in Pierce was something different, if I recall correctly. But I mean, I agree that the judge looked at it all holistically, but ultimately, the new spouse's financial circumstances did not factor into the rationale beyond calculating the husband's household expenses. Is that accurate?
yes, because in our alimony reform statutes include the consideration of a new spouse's income and the modification of a support obligation. That's cited in my brief, Your Honor. That
could you repeat what you just said?
Yes, so there's a statute that precludes the consideration of a new spouse's income in a modification action. It's general laws, if I can find it. It's cited in my brief, Your Honor. It's chapter 286.
Right, but you can still consider the lifestyle that the payor spouse enjoys as account of the new spouse's income and financial assets, right?
Certainly, but you don't have to create a parity of lifestyle between the parties. I don't think that's the intention when you have a retirement situation.
And that's what I'm asking. And that's what I'm asking, which is that the judge looked at everything, but then ultimately decided that she's not going to consider the lifestyle that the husband enjoys on account of his new wife.
No, I mean, she did look at it. She made findings that he belongs to a country club, that by virtue of the fact that he lives with her, he's able to enjoy a life. She did make findings on it, but notwithstanding that, determined that given all the circumstances, that the decision was appropriate. I do agree, you mentioned this before, that a lot of the case laws with respect to ability to pay would be more relevant, I guess, with respect to other contribution to his expenses. But this case wasn't about that. It wasn't like he was in arrears in his alimony obligation and he had a wealthy wife and he had no assets in his name. I think then you're looking at an ability to pay argument. This was, what's the situation with it? This Pierce speaks to the totality of the circumstances. I do believe that lifestyle played a role, and I do believe his legitimate retirement played a role. Despite the fact that he has no earned income, she continues to receive alimony. I think it achieved the very semblance of what we try to do in these circumstances. And Pierce is very on point. The only difference here, which benefits Mr. K, which Mr. Pierce didn't have, was an explicit recitation that his alimony obligation would be reviewed upon retirement. Mr. Pierce didn't have that, and that was the issue in that case, whether he would be permitted to retire. But otherwise, the cases are very analogous. And in that case, his obligation was drastically reduced as well, and that was upheld. So I'd ask that you affirm the modification judgment, affirm the contempt judgment, and award us appellate attorney's fees. Thank you.
Thank you so much for your argument. I'm just going to double check with my colleagues to see if they have any follow-up questions, and I see they. Are we having a little trouble connecting to the live stream?
A little slow, but we're now live and recording.
Okay, great. Thank you very much. All right. Let me call the last case on our list today, which is Shirley Esslinger versus the Massachusetts Commission Against Discrimination and others. The number of the case is 2021-0653. I'm going to begin by introducing the panel. My name is Ariane Buno. I'm joined today by Justice Suk-Young Shin and Justice Sabita Singh. And I want to start with telling you, Ms. Esslinger, since you have not argued, I'm assuming you have not argued for the appeals court on a prior occasion. So you have 15 minutes to present your argument, and you will go first. There is no rebuttal on the appeals court. So once you finish your 15-minute argument, you cannot respond to anything that you might hear being said by the other side. Okay.
Okay.
All right. And then after you finish your argument, you'll be followed by the attorney for the, referred to as MCAD. We'll also have 15 minutes to make your argument. So upon occasion, we have a little bit of technical difficulty. We've had a great morning so far, no problems. If we do, just be patient. Someone will contact you. We usually resolve any problems very quickly, and no one will lose any time as a result. That said, I think we can go ahead and begin our arguments. And Ms. Esslinger, you will go first. You can start now.
Thank you. Your honors, may it please the court, I am Shirley Esslinger, and I will be representing myself pro se. This is an employment gender discrimination case in which there have been non-legitimate barriers placed in the legal process, preventing the courts from understanding the discrimination that I have experienced. The first issue that I'm going to speak to this morning is about comparators and the hearing officer's misrepresentation of case law to expand the comparators for this case. The case law states that comparators need not be identical, but should be substantially similar in all relevant aspects. The hearing officer's decision in this case enlarges the comparators from the other two Mass Highway deputy chiefs to what she calls all high-level managers subject to layoff or reassignment. And she's citing case law trustees of health and hospitals to do this. However, in that case, the complainants did not challenge trustees' selection of the employees to be laid off, just the manner in which they were being laid off or which it was implemented. And so when they were walking out the door, they were complaining about discrimination of how they were treated. The selection of specific employees for layoff requires different relevant aspects, which the hearing officer left off of her description, such as qualifications, performance, or the value that one brings to an organization. MassDOT has provided no documentation of a selection process or criteria to compare employees for layoff. However, verbal testimony initially stated on the third day of the hearing, which was over 6 years after the discrimination occurred, the Secretary's of Transportation's clear directive was said to be no duplicate positions would be allowed. The hearing officer arbitrarily changes the meaning of this clear directive to include the word avoided. And in her decision, she says that all duplicate positions were to be avoided. And as discussed in my brief, the other two Mass Highway deputy chiefs had positions that were very much duplicate and redundant to the white male that was given my position, which included no duplicate responsibilities. And he was also misrepresenting or illegally representing that he was a registered Massachusetts structural or professional engineer, which he was not. And by including the word avoided, that has now been carried over to the briefs and other places, and this was not included anywhere in testimony. I would also like at this time to object to some of the statements of facts in the attorney's briefs, but I understand I'm not supposed to argue those, but I am wanting it on the record that there are statements specifically on the commission's brief on page 13, where it claims that my direct supervisor, Chief Engineer Tramatozzi, was agreeing with testimony, when again, you will not find that anywhere in the actual testimony. I would like to go on to the second issue, which is, wherever it's at here, my legal rights were violated during the hearing, and I have been prejudiced by the commission's investigation and hearing. I was not allowed to testify after the pretext reasons for my removal from my position as deputy chief were first presented again on the third day of the hearing, which was again 6 years after the discrimination occurred. The hearing officer.
Ms. Esslinger, I'm sorry to interrupt. I just had a clarifying question.
Sure.
Did you intervene in the proceedings before the commission?
At the time, I couldn't even define what that word means, but what I'm understanding is that, yes, I was considered an intervener, but as I say, I was, and you'll see in this next section, I will speak to that, of what I was not allowed to do, but yet they've claimed that I had the opportunity to do it.
Did you file anything asking to be an intervener?
No.
Okay.
As I say, I did not know what that meant at the time.
You were represented by counsel at the public hearing, correct?
No, I was.
You were pro se at that point too?
No, wasn't that either. The commission says or claims in all their briefs at this point, the commission claims that they prosecuted the case on my behalf, but they've made it very clear in all their written statements, they were not representing me at that hearing.
Okay, so when you testified at the hearing, you did not have any private counsel at that
No.
time?
No, I did not.
All right, thank you.
The next issue that I was going to speak to is about my legal rights. And the hearing officer cites case law in the, McDonnell Douglas Corporation versus Green, which is a 3-stage burden shifting model of proof of discrimination. And at the 3rd stage of this model, the case law states that the employee must be afforded a fair opportunity to show that the employer's stated reason was in fact pretext. Commission counsel, as I just pointed out, was not representing me at these proceedings. And over 6 years, on day 3, MassDOT would provide testimony stating false, undocumented, unsubstantiated pretext reasons for my removal as a deputy chief. This was the first time this information was provided. And prior to the hearing, the commission documented that MassDOT had provided no explanation for why the white male who was illegally representing himself as a Massachusetts professional engineer was chosen over the complainant, nor had they offered evidence that the white male was more qualified than the complainant. MassDOT has never produced any documentation for a fairly administered selection procedures for employment selections. There was no objective criteria provided. No depositions had been taken to document or preserve testimony. Interrogatories were allowed almost 3 years to be delinquent, which allowed MassDOT to use false and future information that was not known in December of 2009. The commission determined that questioning the witnesses that would be called to testify, and in doing so, the commission was able to determine what would be contained in the record and whose testimony would be excluded. At their request, I provided a list of over 30 people who could substantiate my claims, and several were listed on a pre-hearing memorandum that was going to testify. However, no one was called to testify on my behalf except for myself. I was not allowed to testify after the reasons were first given on that 3rd day. I was not allowed to submit rebuttal evidence, which I did give to the commission counsel when the hearing officer requested that I bring in a copy of a response I had received from the Board of Registration. And the other issue I would just like to call your attention to has to do with a argument that the appellees cite, and they call or cite Fish versus the Board of Medical Registration. They cite this 4 times in their argument, saying what the courts cannot do. And all I'm asking your honors to consider is also included in that case is the statement that they found that a reviewing court may vacate an agency's decision as unsupported by substantial evidence if the decision provides no means of analyzing the agency's assessment of credibility, which the hearing officer failed to do. The AG's brief attempts to answer this question, but I would argue that a person's position does not equate to guaranteeing credibility. It may speak to expert testimony witnesses, but not when the person has a motive to cover up discrimination. And history has proven that even the President of the United States has lied under oath when they felt they needed to do so. I appreciate
I
it.
just wanted to double check something in terms of your argument. So on the third day of the hearing, Ms. I don't know exactly how to pronounce her name.
Paywansky.
Say it for me again, please.
Paywansky.
Paywansky testified. And when you're saying that there was evidence that was presented for the first time that you were not able to rebut, are you referring to her testimony?
Yes.
Thank you.
If there's no other questions, that's all that I have for this morning.
Okay, I'll see if my colleagues have any follow-up questions for you, and I don't see any. So thank you very much for presenting your argument today. And now we'll hear from Attorney Milanzan. I don't think I'm pronouncing your name correctly either. Let me go a little bit slowly with it and see if I can get it correct. Milananzo Godet, is that correct?
That's correct, Your Honor.
Okay.
Thank you. May it please the court. The matter currently on review before this court is supported by substantial evidence, is free from error of law, and is founded upon lawful procedure. Now, Ms. Esslinger has raised concerns regarding her opportunity to present fairly and fully before the MCAD for her hearing. And briefly, I'd just like to respond to that. A matter brought before the MCAD is heard in an administrative prosecution. General Law Chapter 151B is a dual remedial statute. When a complainant brings a case at the MCAD, they have a right to remove the case to Superior Court under 151B Section 9 and seek a private right of action. Alternatively, they can keep the case at the MCAD and the case will be tried in the public interest under an administrative prosecution. Ms. Esslinger does not dispute the fact that she kept the case at the MCAD for a public prosecution of the matter. Additionally, Ms. Esslinger does not dispute the fact that Commission counsel prosecuted the case in the public interest and not in her private interest. Now, what Ms. Esslinger does object to is she does object to the litigation strategy that was used by the Commission in this matter and the ultimate outcome, neither of which was based on an unlawful procedure, and all of which is supported by 151B and the presentation. Additionally, Your Honors, I would like to say that Ms. Esslinger was afforded a full and fair opportunity as stated by General Law Chapter 30A, Section 11, which talks about the opportunity to present witnesses, an opportunity to cross-examine, an opportunity to rebut evidence. The prosecutor in this case, the Commission counsel who prosecuted in the public interest, presented the case as she saw the evidence, and it was fairly reviewed by the MCAD.
So there was no intervention granted, is that correct?
Ms. Esslinger was an intervener in this case.
She was or was not?
She was an intervener in this case.
She was.
Yes, the case as heard by the MCAD was the Commission Against Discrimination and Shirley Esslinger versus Mass DOT. Her role is provided by Section 5, is that of intervener.
Well, what does that mean as a procedural matter?
As a procedural matter, she is present at the hearing, and she is the individual who provides the evidence for the Commission to go forward in the prosecution. Additionally,
is she allowed to present her own witnesses and her own evidence? Is that afforded to her as an intervener?
The opportunity afforded to her by statute is that to present the evidence to the Commission for purposes of the prosecution. She does not necessarily represent herself in the case. If we take a look at Section 5 of 151B, the statute does say that the case is prosecuted in the name of the Commission, that it may be prosecuted by an attorney from the Commission, and that the reporting party, the complainant in this case, is an intervener, and they are allowed to give testimony at the case, and that's what's provided by the statute.
it's not intervention in the sense that we understand it in a judicial proceeding.
It's
Where
not,
there's truly a distinct party who presents their own evidence. It's not like that.
it is not like that, Your Honor, that's correct.
So when the hearing officer's decision refers to, for example, the complainant submitting however many exhibits, that's referring to the MCAD, right? Not Ms. Eslinger herself.
That's correct. It's the evidence that came in through Ms. Eslinger.
But it wasn't as though she presented those exhibits separately.
Correct.
Okay. Okay, thank you.
Okay. Additionally, if I may briefly, I just want to touch on Ms. Esslinger's concern regarding the comparators that we used in this case. Now, Ms. Esslinger is correct that trustees of health and hospital does stand for the proposition that comparators need only be substantially similar in the relevant aspects as to the adverse employment action. Here, the hearing officer was looking to the most probative evidence on the question of discrimination, and in doing so, properly expanded the pool of comparators to include all of those senior managers who were affected by the merger of this case. All of those who may have had their positions eliminated, they may have been repurposed, they may have been redeployed. And in doing so, she used that probative evidence to determine whether or not Ms. Esslinger was subject to gender discrimination. There was no error by the hearing officer in expanding the pool in order to get to the most probative evidence. Now, the matter pending before this court, as I said, it is supported by substantial evidence. And looking at the facts of this case, what we have is Ms. Esslinger, who is a highly regarded senior manager at Mass DOT, who after the Transportation Reform Act and the merger of Mass Highway and the Turnpike Authority was subjected to a termination that was the result of which was the result of the merger itself and the fact that there were many senior management positions that needed to be redeployed, repurposed, or eliminated, that there was no discrimination that occurred with that. Now, the findings of the hearing officers, the credibility determinations, the evaluation of the evidence, the reasonable inferences drawn therefrom, as well as the application of law and the conclusions have been well briefed by the MCAD and by the Attorney General's office. So for that reason, I will be resting on the arguments. So unless the court has any questions.
I do have one question that's more of a not really a housekeeping matter, but does the record indicate why it took 6 years before the public hearing was held in this case?
The record doesn't reflect why it is that it took 6 years before it made it to public hearing in this case. Unfortunately, there are some cases that do take time before they do get to public hearing. That is something the commission has been working on in order to remove that backlog. And if there are no
question.
Sorry, go ahead, Justice Singh.
Could you address the other party's concern regarding the ability to rebut the evidence of pretext that she heard for the first time at the hearing?
There was an opportunity to rebut any type of evidence that came forward on pretext. The attorney who was prosecuting this matter employed a strategy where she felt that if any evidence that came forward needed to be rebutted, she certainly could have called Ms. Esslinger back to the stand in order to offer testimony on that. However, the attorney did not believe that any evidence that had come up would, or there was any need in the prosecution to recall Ms. Esslinger to testify. It was a strategy called by the attorney at that point in time.
When the complainant makes the election whether to proceed through the administrative proceeding or through a private action, are they given any sort of sense of how long the administrative process will take?
They're not specific. I would say no, Your Honor, that they're not specifically given any type of an idea of how long the process will take. It's really dependent upon the facts. I do know that there are discussions regarding how long it possibly could take. Some cases go through very quickly and some cases take longer. But the administrative procedures are slow and they do not move as quickly as, you know, the judicial system may work.
So there's no schedule that's issued or any sort of something akin to a tracking order that's issued at the start of the proceeding?
There is no tracking order, Your Honor. However, you know, there is conversation describing the system itself, describing the fact, you know, that we have an investigative process that then turns into a conciliation process that then goes through a litigation process that brings us to a certification process at the MCAD, and then finally a public hearing, and then appeal to the full commission, then an appeal to the Superior Court, and an appeal to the appeals court. And, you know, there's no time frame that may be placed upon that, but, you know, there's a complainant is generally put on notice that these different touch points do occur during the process.
But I mean, you can understand how a complainant might be surprised when 3 years go by and there still hasn't been, you know, answers to interrogatories, and it's been 6 years. 6 years later, the public hearing occurs. That, I mean, you can understand that that would not be within maybe the realm of someone's understanding when they start the process.
I would agree that it may not be within their understanding. We do try to educate them as best we can. And additionally, you know, 151B is a dual remedial statute. So the complainants have some knowledge of the fact that they can bring the case to Superior Court and pursue that private right of action, which does take the MCAD prosecutorial role and full commission appeal out of the time frame. So they're not prejudiced if they.
But if they're not on notice of how long it's going to take, that might not factor into their election. That was the basis of my question to begin with, which is, are they given any notice of how long it might take? And I hear the answer to be not really.
Well, I would suggest, Your Honor, that it's yes and no. That they're put on notice that there is a process, and it's a very long process at the MCAD. That, you know, we try to educate them that it's going to take a long period of time to get through this process. But because the process, you know, can change as far as discovery is concerned, or other parts of the process, that it's hard to put a specific time frame. In the perfect world, we would be able to, but we can't at this point. So, so at this point, if there are no further questions, what I would ask is I would ask that the court deny Ms. Essinger's appeal, and they affirm the decision of the MCAD. And with that, I will rest on the briefs.
All right, I'm going to just see if my colleagues have any additional follow-up questions for you, and I do not see any. All right, so we'll take the case under advisement. Thank you both for your arguments today, and thank all three of you for the briefs that you filed. We will review everything again even more carefully, and we will again answer